Good morning to each and every one again. Thank you very much for joining us also for this third and final lecture of Judge Péter Paczolay. Today it's going to be quite fun, I'd say, because Péter would talk about the judicial interaction in the enforcement of human rights on international, regional and national levels. So the dialogue, direct or indirect, between courts, situated at different levels. Just one small caveat before leaving the floor to our honorable guest. We'll take a pause in between the two halves of the lecture. As my students know, the pause is graciously awarded only on the condition that after the pause, not only the bodies, but even the minds get back, okay? So thank you very much for being here and for your attention, and now I leave the floor to Judge Paczolay.
Thank you indeed. And thank you to coming back the third time to listen to my lecture. The topic of today is the judicial intercode dialogue, etc. is basically has been already addressed, especially when yesterday I was speaking of the margin of appreciation, which is the relation of the court to the national authorities, including the national judiciaries. So I promised already 2 days ago to have an example where to say that this margin of appreciation and the European consensus might cause not only advantages to the national jurisprudence, but might also cause some problems. And for this, I chose an example from the Hungarian Constitutional Court's jurisprudence. As I mentioned already, that the Hungarian Constitutional Court, when it started to work in 1990, at the beginning of 1990, being the first newly founded constitutional court after the political changes, because Poland has already a constitutional court from before, but this court, the Polish court at that time, has limited powers. For example, was not able to turn down, to annul laws, just to sign to the legislator that this is unconstitutional and the legislator should replace it with a constitutional provision. And the Hungarian court was very ambitious. I have to say, I was interviewed recently regarding my relation to the president of the Constitutional Court, László Sólyom, at that time later President of the Republic, who unfortunately passed away a few weeks ago, and a lot of interviews and memories were made regarding him. And I considered all my work with him, and also my work at the court as a judge, and the president of the court for 7 years. Still, I say, for me, the more inspiring period of my judicial career was the early 90s, when I was his advisor at the Constitutional Court, and we built from the nothing a new institution inspired by the foreign courts. As a matter of fact, the very first visit in February of 1919 was to the Italian Constitutional Court. At the time the president was Saia, and then we had close relations with the German Constitutional Court, of course, and with the Austrian. We had exchanges since 1990 every year with the Austrian Constitutional Court. Of course, they are neighbors, but it's easy to organize. Even during one way, usually we met at the borders of the two countries, 1 year in Hungary, another year in Austria, and so on. So that also attracted international interest in the work of this newly founded court, with these huge ambitions. And the court was addressing basically all the important issues of constitutional justice, but also peculiar issues that were linked to the history of those countries that came from the Soviet bloc, namely how to face the history, the historical injustices of the communist regime, and so on. Of course, it was not unique, because Germany, to a certain extent Italy, and also other countries had to face the past after World War II or later on, but this was very peculiar in almost all East European countries, not only in the terms of historical justice, to make justice for the political crimes, etc., but also in a sense of property rights, how to remedy the confiscations made by the communist regime. As you know, during socialist time, private property didn't exist. What we had, of course, I had my watch, it was mine, in case the Russian didn't take away, but it was called personal property, so not private property at all, and so on. So all these confiscated wealth, lands, and so on, that had created a lot of problems. I already addressed one of them regarding this Polish pilot judgment that was dealing with the problem of the abandoned land when the boundaries of Poland and the Soviet Union was changed. As regards the influences, also the Strasbourg court had an influence more inspirative than, how to say, factual influence on the court. The Hungarian Constitutional Court was citing judgments of the Strasbourg court already before Hungary joined the Council of Europe and ratified the European Convention of Human Rights. So the convention influenced the judicial review and the interpretation of the Hungarian constitution, but let's say, as actually mentioned, the first president of the court, really a father of Hungarian judicial review, Professor Sólyom, mentioned that in the first formative period of constitutional jurisdiction in Hungary, referring to a given provision of the convention was much more a demonstration of considering and searching for European standards. It was aimed more at linking up Hungarian thinking to European norms than to use this international instrument in its proper role in the course of constitutional review. I have to say that this practice remains. There were several studies made on the concrete impact of the Strasbourg jurisprudence on the Hungarian or other constitutional courts. Was an international survey, and then the use is much more a source of inspiration and how to say, as he said, that a demonstration that we are linked to the European values and standards, and less to solve concrete cases. But this is natural, as I've stressed several times yesterday, that the national judge has to defend the rights enshrined in the Constitution and in the Convention, but of course here the priority is always the Constitution, and that can be used as a much more immediate tool to solve a concrete case before the domestic judge. So the example was the very first case when a Hungarian application arrived still in the old system, in the system when the Commission was filtering the applications and sent few of them to the court. The very first case was in 1999, decided by the court, but still, let's say, in the old framework. And this was a case, was so-called Rekvényi versus Hungary that had a great influence, because it was the very first case when something was not decided at the level of the Commission or at the level of the Committee of Ministers, who could give remedy for the violation raised in the application, but when the court deliberated on a Hungarian petition. And what happened here was basically that the court accepted that in Hungary members of the armed forces, police and security services were prohibited from joining any political party and from engaging in political activity. This rule, also in other former socialist countries, was a reaction to the fact that before, during the communist regime, such, so to say, confidential positions could be filled only by members of the party. And this was a reaction to somehow to take out the military, the police, and other forces from party influence. But of course, this was strange from Western eyes, because it violates, you can allegedly violates the freedom of assembly to join any political party. But it was a fireman actually who was the applicant, and he was complaining that he cannot be member of any party. And the court accepted that the Hungarian regulation to prohibit certain professions to affiliate with any political party as not violating the convention. As the president of at that time of the court, Lucius Wildhaber, said, the court showed understanding for the transitional period of consolidation of democracy. So that this was that these countries coming from a communist regime can justify the introduction of certain measures that how to say, at least limit their fundamental rights, like the right of assembly. In my humble view, this case didn't have an evolving evolutive influence on the Hungarian jurisdiction, but rather an erosive effect on the jurisdiction of the Hungarian Constitutional Court. In the following years, 2000, 2001, etc., the Constitutional Court was referring to this judgment of the European Court of Human Rights in several consecutive decisions, and by this, referring to this permissive view of the Strasbourg Court, basically relaxed the democratic constitutional standards set up by the first Constitutional Court. Of course, in the meantime, to explain also the changes, in the meantime, the first composition of judges left the court, including President Sólyom, and new judges, new president came, whose philosophy, constitutional and judicial philosophy, was generally different, much more self-restrained, not that really enthusiastic activism that the first court exercised. At that time, I was, since '96, I was the Secretary General of the Constitutional Court, but honestly speaking, just between us, confidentially, I couldn't stand this new court, so I left the court and couldn't stand even the second president especially. So I left, and of course this also explains that I'm quite critical with this, so to say, second Constitutional Court composition, because this went again the original philosophy that what we created in the 90s, that the court had to elaborate a philosophy, a position regarding this transition. That was one of the issues, the most important issues that we had to deal with. But the court firmly stated in that connection, in the connection of the transition, that unique historical circumstances of the transition and the given historical situation should be and could be taken into consideration. Of course, we are not blind. You see that it's a transition. It's not a consolidated Western democracy. We have the burden of the previous 4 decades, a different political system that had not too much to do, so to say, with democracy and the rule of law and human rights. But as the court said, in a famous decision on historical justice, that the basic guarantees of the rule of law couldn't be set aside by reference to historical situations. So that was the basic principle that, of course, take into consideration the specific circumstances of the transition, but the basic guarantees of rule of law cannot be set aside by reference to historical situations. In 2000 and the following years, the court, the new composition of the court departed from this interpretation, and in some decisions limited the freedom of expression and freedom of assembly, quoting this judgment of the Strasbourg court that was how to say, so permissive regarding the transitional period. In earlier decisions, the court also consistently assessed the historical circumstances, the changes in the political regime that has affected, acknowledging that such circumstances might necessitate some restrictions on fundamental rights, but it never accepted any derogation from the requirements of constitutionality based on the mere fact that the political regime had changed. Legislation justified by the change in the political regime and the restrictions contained in such laws had to remain within the limits of the Constitution. That was the argument of the first court. And in the decision or the decisions that I'm criticizing, the Constitutional Court adopted the terms actually used, the terms and words used by the Strasbourg Court in the Requeni judgment, I quote, regard being had to the margin of appreciation left to the national authorities in this area. And the court finds that especially against this historical background, the relevant measures taken in Hungary in order to protect the police force from the direct influence of party politics can be seen as answering a pressing social need in a democratic society. Thus, the decision of the Strasbourg Court unintentionally, so I was not happy with the Strasbourg judgment either, but let's say that unintentionally had an impact that to Hungary that lowered the standards set up by Constitutional Court in the first decade of its functioning. Of course, also this the issue that we are addressing already the third day, the universality, universal acceptance and validity of freedoms, human rights and values, how is relativized, and this relativization of course serves well-funded goals as well. But honestly speaking, for example, here I had the feeling that this is not just to take into consideration the particular circumstances, the margin of giving margin of appreciation to national, to different countries. But here, and this, it was even mentioned in the text of the judgment, that basically different standards might be applied to consolidated Western democracies and to the new democracies. And this kneeling for me had the message that double standards can be accepted in the practice of the courts. So different countries, so how to say, different groups of countries can be evaluated and just adjudicated on different standards. I will give another example for this, how this works in 2023 and not in 1999. So I would say that why I mentioned this concrete case, that in the international standards, very, how to say, I fully accept and understand what was the topic, especially of yesterday's lecture, that the respect for national or other communities' distinct legal tradition on the part of the Strasbourg Court should be welcomed as an instance for judicial self-restraint. But reducing the level of protection afforded by domestic courts on the ground of lower minimum standards in the absence of consensus is not acceptable for me. So that there's at least I think accepting also, how to say, the reality that at least certain hardcore human rights should be defended even against the majority of the countries, even when there is a consensus, like the German legal philosophy uses the so-called unalterable basic rights concept. I addressed this issue at the usual January workshop of the court, and also published it. And my mother was wondering why I became a judge after all that. And okay. A more technical issue still on the issue of self-restraint is that the very important element, I mean, theoretically not so interesting, but a very important element and very much debated if you read the judgments of the Strasbourg Court. It's almost all important judgments first address the issue of the exhaustion of domestic remedies as an essential part of subsidiarity. This is seems a technical issue, but it's very important also the philosophy of this subsidiary role of this international court, and the Convention, Article 35 of the Convention is very clear on this issue, saying that the court deals only with matters after all domestic remedies have been exhausted. And nowadays, since Protocol 15, it gives 4 months after the final domestic decision to apply to the court. Previously, it was 6. Here, the aim is clearly to reduce the still incredibly high number of applications arriving to the court. So here, the subsidiarity that I addressed several times, here the philosophy is that it is the responsibility of the member states to remedy the violations against the convention, and therefore the applicant has to go all possible fora in the domestic legal system, and not only, how to say, the ordinary instances of the judicial system, but where a constitutional complaint exists, even to exhaust the constitutional complaint. This, of course, created quite a number of problems, because the court says that, of course, the exhaustion of the national domestic remedies is an important element of the functioning of the entire system of European supervision, but nevertheless the court applies this rule, this exhaustion rule, with flexibility and not in a formalistic way. But basically the standard is that the domestic remedies has to be first of all available, they should exist, they should be open for the applicant in the concrete case, and they should be effective. I mean, an ineffective remedy is ignored by the court, or the applicant can raise that it exists, let's say, exists a constitutional complaint in the system, but is not effective. Basically, nobody receives a remedy from the Constitutional Court, and so it's ineffective. This is a very delicate question. It seems quite simple, but not. We have to sacrifice a lot of time to measure the effectiveness, the accessibility of these national remedies, and it changes country by country. For example, for the length of procedure, certain countries open up the Constitutional Court. So if in countries of the former Yugoslavia, the constitutional courts are overloaded by constitutional complaint, because against the length of the judicial procedure, you can have a constitutional complaint before the Constitutional Court. In Hungary, this is, for example, impossible. So, I mean, as the length of procedure is not a constitutional right, I mean, to have a is not in the constitution or not in the legislation, the constitutional complaint cannot be based on the length of the procedure before the ordinary court. In Poland, since 2004, there is a law. The law was adopted that regulates the compensation for the length of procedure at national level. So this is differing in each country. Then also, of course, the constitutional complaint, as existed in Hungary before, I mentioned it was basically a system based on the abstract review of the laws, and in very particular cases, the court could give remedy for the individual who raised the issue. But then the commission, not even the court, the commission at a very early stage, the early 90s, declared that the Hungarian constitutional complaint is not an effective remedy because it's not accessible by the individuals. Then, with the new constitution called Basic Law in force since 2012, this is the constitution that is the constitution of the present government in power now for 13 years. They introduced this new constitution, which, among others, this was my great personal conflict with this government that restricted the powers of the Constitutional Court, saying that the Constitutional Court cannot review laws regarding taxation and the budget, which, honestly speaking, very rarely violate tax laws, the Constitution, or the equality, because usually it's very rarely say that only the blonde and blue-eyed people are taxed, etc. So it's very, very difficult. But then my position was that I also had the possibility during the debate on the draft of the new constitution to express in the parliament that the legal system is integrated as such, cannot say that certain part of the legal system does not have to be in conformity with the constitution. So you cannot take out any part of the legal system from the requirement of constitutionality. So my position ignored by the majority, by the constitution making a majority, but somehow, I don't know, maybe to compensate, because I was and a lot of other constitutional judges and academicians were in favor to introduce a, so to say, real constitutional complaint on the German model into Hungary. So I don't know why, to consolate me or anyway, so they said that we will introduce a constitutional complaint system as you would like. it. And then they choose the German model because that cannot be attacked at international fora or at the Venice Commission, etc., because that's the German is the real model of constitutional complaint. So that was introduced into Hungary. And then the issue of, that's also an example how politics and law interplay. Then there was an issue at the Strasbourg court whether this new remedy is effective or not. And it was very stressing for certain countries, for judges from certain countries, where a similar solution was in force, like let's say Slovenia, Lithuania, and so on. And they wanted to say, declare that the Hungarian system is effective, the terms of the convention, also to protect the effective character of their constitutional complaint. My predecessor, outstanding, excellent, internationally famous lawyer, Professor Sajó, was postponing always this decision. And when I arrived to the Strasbourg court, I didn't know what happened, because they were coming on me, immediately prepare a decision that is an effective remedy. I said, wait a minute, we cannot declare something effective with retroactive effect and then throw out thousands of applications that arrived, understanding that the constitutional complaint as such is not an effective remedy in Hungary. Okay, finally we made 2 applications, and we explained in a decision, because that means that the application was inadmissible, that the constitutional complaint is effective. The applicants didn't exhaust this remedy, so therefore they struck out their application. It was very, some of the lawyers, especially those who are clients at the Strasbourg court, were very critical, and they attacked also me personally, that as president of the Constitutional Court, previous president, I should know that the constitutional complaint is controversial and blah, blah, blah. I didn't understand the argument, because in Germany, the effectiveness of the constitutional complaint is about around 3%. So and then 97% of the applications is thrown out. Hungary has, through similar statistics, but nevertheless. But then I have to admit also self-critically that situations can occur when it turns out the constitutional complaint is not an effective remedy. For example, in Hungary also as on a different way, but there exists sentence imprisonment for life tenure, but with a real life tenure. So those conducted for that can never leave the prison. I think similar a little bit with those mafia criminals who don't work together, etc. But the difference is between the 2 solutions that Hungary, this is expressed in the criminal code, that they cannot be released, never. And there were two kind of, then later on a little bit watered up the regime, that even those who are sentenced for life, this real life tenure, and a review has to take place after 40 years, if they still are living. And so there are the 2 systems, without review and now with review. I dealt with the Constitutional Court. I have to say that my personal position is that is unacceptable. So but then I left, and still now after, don't know, 10 years, the Constitutional Court still has not decided on this issue, because they are so, how to say, fragmented. People's often lawyers ask me that why, even I remember the Minister of Justice asked me that why you are not taking a decision in this and that case, because there is no majority. Okay, you vote and then there is no majority because we have at least 3 different opinions, and from the 3 different opinions an absolute majority does not come out at all. So this constitutional complaint are blocked at the court. Of course, the Strasbourg court is also very slow. So it's very funny when we say that because the length of the Article 6 fair trial is violated because of the excessive length of the procedure, and then after 8 years we decide on an application. And but here I was also patient, was waiting, but I don't know, after 6 years I couldn't say that I'm still waiting for inspiration or whatever else, so I had to declare that the constitutional complaint regarding applications on this real life tenure cases is not an effective remedy, so we don't wait for the Constitutional Court and we go there. So it's an interesting part of our practice, and also it fits into this framework that we are dealing with the international court vis-à-vis the domestic authorities, including jurisprudence. So this is who deals with the issue sees that there is also in the academic literature a lot of opinions are expressed regarding the exhaustion principle and how to evaluate these elements like accessibility or effectiveness. Of course, I try always to show both the pros and contras for these institutions, not to confuse you. It's enough that I am confused, but just to show that all these issues are, how to say, very borderline issues, very complex issues, so it cannot be approached just with a clear and very prompt view. And also the margin of appreciation, I stress several times, for me, I think that's a very good tool in the practice of the Strasbourg court, the first real international court on the European level for human rights, to keep this balance with the national authorities, with the proud sovereignty of the states, etc., but also giving effective remedy for the violations of the convention rights in individual cases. But also the margin of appreciation is criticized, as I did, because of the lowering of the standards, which I didn't say that this is the margin of appreciation is how to say, culpable for that, but nevertheless the effect was one. Let me mention some criticisms from the academic literature, also from courts and the judicial authorities. Some commentators say that the principle is applied almost automatically. So we say that and the states enjoy a margin of appreciation, etc., without carrying out a substantive evaluation of the concrete fundamental rights involved in the case. A second issue is, it's very interesting, that we are very proud and generally is well accepted that the Strasbourg court uses the margin doctrine. But if you look at the practice of other international courts, you found that they not only reject, not only they do not use the margin doctrine, but they reject it in principle. That they consider it irrelevant. It's an irrelevant doctrine that do not actually refuse to apply this method. They say that the court, an international court, should conduct an objective analysis of the state responsibility based on the provisions of the convention. So not to play this deference vis-à-vis the national authorities, but objectively examine, as a judge does the domestic level in a criminal or civil, whatever cases, what is the responsibility of the state, and not let the state out of the responsibility, referring to the margin of appreciation. Further, critics call it an empty rhetorical device that creates legal uncertainty, because the wideness of the margin of appreciation depends on the context, on the concrete cases, and that means that you can predict that the court will use the margin doctrine, but you cannot predict what, in how extent will find this margin applicable for the concrete case by the defendant country, and this makes unpredictable the jurisprudence of the court. Then, finally, now this margin doctrine was linked to something invented newly by the court, I mean, like 10 years ago. And this is how to connect the margin of appreciation doctrine to the quality of decision-making in the national authority. What does it mean? This was invented by the court in 2013 in a famous case, of course, again against the United Kingdom, the so-called animal defenders against the United Kingdom before the Grand Chamber. It was a very controversial judgment, 9-8. So with one vote majority it was adopted regarding violation of freedom of expression. And the issue was a statutory prohibition of paid political advertising on radio and television during the electoral campaign. And this Animal Defenders International, it's ecological NGO, was banned by the broadcast authorities in the United Kingdom to leave the TV campaigns for animal rights during the electoral campaign, during the political campaign. And this administrative decision was reviewed by the High Court and also with the House of Lords at that time, a Supreme Court, and they rejected the complaint of the NGO. What the court did, they praised the extensive deliberation before the Parliament and at two instances before the highest courts in England. And it said that the quality of parliamentary and judicial review basically made it not violating the convention, said that the necessity of the measure is of particular importance, including the operation of the relevant margin of appreciation. And they ended up in no violation, which was furiously attacked by the minority, the 8 judges against the 8, because so I mean, if you have a detailed parliamentary debate, you can adopt a law or an administrative decision that violates the convention. And the critics rightly say that impact of such inconsistencies is perceived even more from the clear mismatch between granting a narrow margin and not thoroughly analyzing the merits by being deferential to the national authorities' interpretation. As one critic says, the court makes an external assessment of the procedure, of the parliamentary procedure, without addressing the merits of the case. You could hope that this was a unique issue some also suspect that there were so many conflicts with the United Kingdom and between the court and the United Kingdom that they wanted to whitewash this violation of the freedom of expression. Unfortunately, this year, a similar judgment was delivered, accidentally in a Hungarian case. So I'm not moved because of the Hungarian, because it was a Hungarian case, because I was hesitating a lot what position take in this issue. The issue was that in Hungary, as in almost 10 other countries of the Council of Europe, the name and certain personal data of the great tax debtors is made public. That this guy has a tax debt for more than half year in this sum, and his name is XY, and he lives in this city and under this in this street. And this was challenged by one of these great tax debtors, and I was hesitating, but I found also taking into account the parliamentary debate when this was introduced, this provision was introduced in 1995. So after a few years of the not only the political but economic change, that from a communist economy changing to a private market economy, that was, how to say, it's not the nicest procedure, but in history you experience how all these elements from the corruption, from everything enters, tax avoiding and so on. And therefore the government wanted to stop this basically uncontrolled tax avoiding practices and so on, and they introduced this provision making public, and this seemed the lightest interference, because if you put the mother names or the age or the date of birth, etc., these are much more personal than the address, the home address, which first of all, for example, in this concrete case, we knew, of course it didn't play any role, that the guy was not living on that address that was revealed. And also now you can change, you can have 3 addresses, etc., and so on. While if your mother names is published, what does your mother do with this, that you are avoiding taxes, etc. So after a long hesitation, during the COVID pandemic, so I had time, I said that this does not violate the convention. And then at the Grand Chamber, where I was the national judge, I saw that some people say that this violates, because this is a very sensitive data, I don't know why, but anyway. But I was ready, if a majority says that to reveal this, the home address violates the convention, I'm not writing a dissenting opinion. I changed my mind, my position, and I joined the majority, because that's the majority's point. No, instead of going to that way, they found, they applied the animal defenders test, whether there was a deep parliamentary review. I told them, it's also in my dissenting opinion, that there was at the beginning, still in this euphoria of democracy, it's a very long parliamentary debate. And basically the provision is unchanged since that. So why to have a parliamentary debate every time that the tax law is changed when the provision remains the same, etc. So also factual is not true what the position of the majority. But then they say that criticize the quality of the parliamentary review conducted at domestic level and the balance struck by national authorities between the competing individual and public interest. So I disagreed with both the court's approach and the outcome of the case, deploring that finding a violation was based on alleged shortcomings in the Hungarian parliamentary review of the measure. One concurring judge who was in favor to say that this violates the convention, I mean the revealing, he said that he was even more critical with the Grand Chamber than myself, and said that the Grand Chamber invalidated the measure based not on analysis of its merits, but because it had not been preceded by proper parliamentary debate. As Judge Giudice rightly underlined, the use of the quality of parliamentary review yardstick substituted the examination of the issue raised by the applicant. They tried to calm me down, saying that this is just a minor violation. But I told them that my problem is not that Hungary is found violating. My problem is, I'm sorry to say, with the mental state of the Grand Chamber. That what is this? And especially, if you look at this, I don't want to elaborate on the double standards issue, and I mentioned just one. In the English case, in animal defenders, the quality of parliamentary review served as an additional argument in favor of finding no violation. And in the case against Hungary, this became the decisive factor in finding violation. So what was used to find no violation here was used in the inverse to find violation. My only hope is that this animal defenders approach will not be extended further. And also, I couldn't understand what is this. Only Peter, calm down. This is just a minor violation. But that's a minor violation. Violation or not violation? I'm pregnant or I'm not pregnant. So I'm a little bit pregnant. So. Okay. So enough. Let me conclude on this part of the lectures. So I just repeat where I started, that in my overall view, the Strasbourg Court have the potential not only to set European standards for the protection and enforcement of human rights, but also to set universal standard, as one of the, I quoted from somebody that even they are just applied to the persons on the territory of the member states, but they have universal moral standards. And also, finding balance between the evolutive interpretation of the conventions and the limitations on the international court powers, I think that the use of margin of appreciation as an important argumentative framework is useful, even if other international courts do not use it. It makes possible to have a balanced relationship with the sovereign member states. The use of this tool is, as I mentioned, is not accepted without criticism regarding the function, the scope, the consequences, etc. However, anyway, now historically and seeing the Strasbourg Court could make broad use of it due to the context of the convention and the historical legal setting of the Strasbourg Court, and I think that it will be used and should be used in the future, maybe taking into consideration the criticism, addressing systematically and openly the problems with the application of margin of appreciation, so not remain silent on this criticism. And fortunately, I often find that the court just does not hear the critics, except what happens with the relation of the United Kingdom, where the critic is so sharp and also is so frightening for the future of the court that they have to take into consideration. Let me check those the time. Let me give a few minutes. So the court, as I have continuously repeated, was born under a specific historical circumstances, but very, very lucky in circumstances. And of course, it was not the first attempt to set up a court with effective powers to enforce positive rights that I addressed at the very beginning 2 days ago. Of course, in the international law that was generally considered as a soft law and very much in the hand of the states and not as an autonomous legal system, there were nevertheless attempts to set up international courts. There was an arbitration in the 19th century between countries. For example, this famous case between Peru and Japan, where the Russian star was the arbitrator in one person, and so on. So the arbitration involved for these international conflicts, and then the Court of Justice in the beginning of the 20th centuries became the first permanent court of these issues, and then what later became the International Court of Justice was set up, and still there was the Hague Court. And of course, there was, after World War II, an important role of the courts dealing with the crimes committed during the Nazi times, like the non-bank tribunal. But strangely, Kelsen, who was the great inspiration, he was forcing that international law should, and international court should be interfered with whatever issues at the domestic level. On the other hand, he was very critical with the use of these international tribunals against crimes committed during the dictatorships, saying that there was no, as he being a legal positivist as well, that there was no ground for that. And therefore that I mentioned Radbruch, who basically came from the same position that Hans Kelsen, but he changed his mind, accepting this relativized natural law to explain the legitimacy of Nuremberg and other tribunals dealing with crimes committed during the Nazi or fascist regimes. So he mentioned that the judicial interaction of at international level. Of course, here we have quite a complicated system. Especially the United Nations has the Commission on Human Rights, which is now the Human Rights Council since 2006, has the Human Rights Committee monitoring the International Covenant on Civil and Political Rights, has the High Commissioner for Human Rights since 1993, is presently an Austrian lawyer, and then at the regional level we have like the Council of Europe, the OSCE in Europe, and the Strasbourg Court. I have to mention, when we speak of the Organization of Security in Europe, the 1975 Helsinki meeting had a very great impact on the whole Soviet bloc. So it really was a huge defeat of the Soviet system, which even the Soviet Union in other countries mobilized the underground opposition, and especially made a topic of public or not so public but underground discussion the issue of human rights. And also in Hungary a lot of organizations were formed, like the Helsinki Committee and etc., and other groups that were dealing with the results taken by the Helsinki Conference in 1975, and then this had a long lasting impact. And when we see somehow how the human rights adjudication is working in this part of Europe, then we have to go back to the these origins. But when we speak of the interaction between the courts and the national level, and especially, for example, the Strasbourg court and the relation to the English judiciary, which is one of the most sometimes dramatic conflict in the life of the court, then we have to take into consideration, I always repeat, that this has an historical explanation. But Churchill initiated the Council of Europe, including the adoption of a Human Rights Convention in 1950 and the setting up the court trying delivering first judgment in 1960. This was something that unprecedented before at the continental level, at the regional level, and this was anyway a historic act, but was difficult to make understand to the sovereign countries that they are not just joined for the sake of a peaceful Europe for the defense of democracy, human rights, and rule of law, but also they had to accept that an international court does something that never did before in the history, despite all the effects, that delivers a binding judgment to a state against the state's legislation, administrative decision, or judicial decision, so that make it acceptable for that. Therefore, the court, the Strasbourg court, has this so many guarantees in defending the member states, that the Commission's filtering role, that only the Commission could transfer to the court the cases, there was no individual application, the national judge just coming from that country was the rapporteur in the case, and finally also that the member state had to agree to having a case against them, and so on. And some of these measures, it was not a permanent court. The judges came once a month to Strasbourg, etc. So it was peculiar. And in Strasbourg, I saw at one of these anniversaries that we have every year, some anniversary, but it was an exhibition in the mayor's office in Strasbourg on the history of how the court, Council of Europe was created. And there I saw that Lord Bevin, who was a foreign minister at that time of the United Kingdom, they were hesitating to put the court, the Council of Europe, either to Strasbourg or to Nice, to Nizza. And both symbolic places that belonged to other country, to the Piedmont or Italy, here continuously changing between German and French rule. And then Lord Bevin's final argument wasn't probably true if it was in the Strasbourg mayor's place that Lord Bevin thought, let's pick Strasbourg because nobody wants to go there, especially compared with Nizza. I have to say that Lord Bevin was right. It's so difficult to travel to Strasbourg and from but anyway, we are there, and also people come. Okay, so that explains even today. Also, what is explained that it was not a permanent court. This 98 is a permanent court, but still the lawyers, the registry cannot digest that the judges are all the time there, disturbing their work. They like very much the judges when they arrive for a few days every month. They don't like us that we are always there and just making confusions and so on. So let me close this returning argument that the fact that an international court is ruling over the member states that are sovereign makes that the implementation of the convention is primarily a matter of national judges, then the national judges are better placed to interpret, that the Strasbourg court is a subsidiary, complementary, and not a first instance court, etc., etc. So all these arguments had to be seen in this context, in this historical context, in my view, and this explain a lot of things. Okay, we promised, promise is promise, a break. So let's have a break of
15 minutes.
15 minutes.
Okay. I see that bodies got back, hopefully accompanied by minds, for the final part of the final lecture of the series. In the end, at the end, we'll have half an hour or so for questions, the Q&A session. Péter speaks wonderfully refined and polished, elegant Italian. So for those of you who are not entirely at ease with putting questions in English, you can certainly do that also in Italian, feel free, as long as you can get a response to your curiosities or objections. And I mean, no further details on my part. I'll leave the floor to...
Thank you indeed. Just, I think I will address two issues regarding this interaction between the different levels of the court. Of course, it's a very important issue. As I've stressed several times, this is the first European court, international court that could deliver decisions that are binding on the member state and so on. So the execution of the judgments is also an important part of the whole mechanism, and of course also of how the universal human rights are applied to the concrete situations and concrete cases. Of course, it is the convention introduced a seemingly effective system of the execution, because besides to deciding that there was a violation of the rights enshrined in the convention and in some of the additional protocols was violated, so the court finds a violation and also has the power not just express the fact of the violation, but also to award just satisfaction for the individual applicant, both regarding his pecuniary damages and also the non-pecuniary damages he suffered for whatever sufferances that was linked to the violation of his or her individual fundamental right. And this this so-called just satisfaction should be paid by the government in 3 months. This is monitored by the Council of Europe, not by the court, rightly, by the way. In my view, there's another organ of the Council of Europe deals with these issues, the Department of the Execution of the Court's judgment, and the decisions regarding the execution and how to say to deal with the countries that do not execute the judgments is the task of the Committee of Ministers, which basically means that the ambassadors who represent the member states, they deal with the execution. Of course, they publish a report every year. And from this report comes out that, of course, at least the half of the just satisfaction is not paid within 3 months. Sometimes there are very long delays, or some countries do not pay at least the half of the just satisfactions. Some countries find on straight excuses and solutions not to pay, and but basically they accept to pay the just satisfaction. The lawyers representing the applicants know that the 3 months is a virtual deadline, and I'm very happy when they receive finally the money. It usually is paid by the Ministry of Justice of the respective country. But the more important part of the execution is, as the court finds more and more systemic violations of the conventions, I mean that not only in the length of procedure that should be then managed by legislation, or let me mention an argument where I think this was first solved in Italy regarding the prison conditions, the detention in prison conditions, that overcrowded prisons, unhealthy environment, and so on and so on. And also there was the same issue in Hungary, that basically then the legislation introduced new standards for the prisons, and also a law that gave remedy. So there is a domestic forum and a domestic procedure to get satisfaction for the bad prison detention conditions. So this was really a good example of how this system works with the subsidiarity, and that the problems should be solved at national levels, and so on. Then, of course, new problems are raised. For example, I saw as a single judge that substituting the single judge for Portugal, that, for example, Portugal still has this problem, and there's a lot of applications arrive. As also in Italy, it was a huge number of applications. In the case of Hungary, it was 8,000 applications pending before the court because of the prison conditions. And now, for example, for Hungary, there are 620 cases, 620 applications pending before the court. So that is a huge difference by solving this. Of course, there are also particular solutions, but not generally, not often introduced. For example, to restore the situation as it was before the violation, or reopening judicial proceedings where the court find violation. But I think that basically what is the most foreseeable solution is to pay the just satisfaction, or in certain cases to introduce general measures. The problem is that the disobedience, so to say, so not just the criticism against the court, but a certain disobedience is raised by certain countries. Unfortunately, as I mentioned, the conflict is the most severe with the United Kingdom, that has, of course, a very distinct legal system, distinct judicial system, even if it's under reform. For example, the creation of a Supreme Court instead of the House of Lords as the highest judicial organ. But then basically the war between the Strasbourg courts and the British judiciary broke out in this famous Hearst case in 2005 that was on the voting rights of prisoners, where the British system does not give voting rights to prisoners. And this was this interesting decision, interesting judgment to read it, because it elaborates a very lengthy way on the margin of appreciation, but then turns to the second phase of the argument, that despite the wide margin of appreciation, there is also European supervision, and according to European supervision, to deprive prisoners of their voting rights, it violates the Constitution. The reaction of the English judges was ferocious, and let me quote the much more quoted it was a farewell lecture a few years after this Hearst case in 2009, and actually I had not in mind when I chose the general title of this series of lectures, The Universality of Human Rights, but unfortunately is exactly the same as was Lord Hoffman's farewell lecture in 2009. And he said that at the level of abstraction, human rights may be universal. But at the level of application, the messy detail of concrete problems, the human rights which these abstractions have generated are national. Their application requires trade-offs and compromises, exercises of judgment which can be made only in the context of a given society and its legal system. So he makes a conceptual distinction between the abstract interpretation of the conventional rights by the Strasbourg courts and the concrete application of these abstract principles at the domestic level. Of course, so there was the famous formulation that human rights are universal in abstraction, but national in application. But what he draws a conclusion from this fact that whatever it is, the Strasbourg courts is not a suitable body to perform the function of a tribunal deciding in concrete cases, not a suitable body. And what he admits that it must be a general interpreter of the human rights, but not interfering the concrete systems. Of course, the court tried to answer to it, but I have to say that when different judges of the Strasbourg court were responding to this thesis of Lord Hoffman, they how to say, wanted to accept that the critics to a certain extent are well-funded when the court applies this general principle to very concrete cases, sometimes to abstract from the context of the concrete, etc., etc. And this was what then those judges entering into this dialogue, if we call like that, said that there is a need for a more realistic approach, taking into consideration the reality of the country, or as that time judge, later also president of the court, Robert Spano, said that the Strasbourg court is entering into the era of subsidiarity after an age of very active role, creating new ways of interpretation, and also new rights not enshrined in the Constitution. Just mention again the right to a healthy environment, which included also very famous Italian cases regarding the Taranto Ilva facilities. Interesting that the other country that at that time was rebelling against the Strasbourg courts, now it's out of the picture, Russia, in some years later of this English conflict, in a case against Russia, again, the issue was the voting rights of the prisoners, of the sentenced people, and then again the court found a violation in the case of Russia, and Russia was very critical with this, and they introduced, there was not only a, how to say, theoretical criticism, but also they introduced a measure that makes possible for the Constitutional Court of Russia to review the judgment of the Strasbourg court and saying that the Strasbourg judgment goes against the Russian constitution, so therefore it should be ignored. This was a very... The Constitutional Court, that was in 2015, accepted this role and announced that it would review the Strasbourg rulings against Russia for their constitutionality. And this was supported both by the parliament, the Duma, both by the government, the president, and this is really under the idea itself, in my view, is underscored this disagreement between Russia and the Strasbourg court about both the substance of human rights and also the ways that how human rights violation should be resolved, because Russia was a member of the Council of Europe from 1996, accepted the compulsory jurisdiction of the court in 1998. The relation was problematic several times. Then I have to admit that despite this soundy introduction of the Russian Constitutional Court of this new role, they use this tool, I think, 2 or 3 times only in very delicate cases, so it did not become a general review of all judgment of the court against Russia. But then all this conflict then became obsolete in the sense that Russia was excluded from the Council of Europe. Still, by the way, just in brackets, I mentioned that the court decided to continue with dealing with continue the procedures with all the Russian applications, and so which is how to say, very strange, because Russia does not answer to anything, does not accept mail coming not only from France but also from Germany, because they realized that then the court brought letters to the German post mail, etc. So it's, but the problem is that the English go further, and they criticize now generally and at the political level the work of the Council of Europe, because only one agent of the Council of Europe, the court, that the court not only regarding but in generally this view of Lord Hoffman was not generalized, because I think that even the lords in the Supreme Court are very much divided on this issue. There were judges and there are judges on the sitting on the Supreme Court who were very close and very attracted by the Strasbourg case law, and so I think that the British judiciary is divided. Nevertheless, recently the government identified itself with this criticism, and at the summit of all heads of state and governments of the members of the Council of Europe in this May in Reykjavik, Prime Minister also publicly but also privately with a meeting with the president of the Strasbourg court made it clear that that United Kingdom is considering very seriously to leave the Council of Europe. I met some parliamentarians in Strasbourg who were shocked that at the Parliamentary Assembly one Lord Hale, one member of the UK delegation, their speech that they are preparing to leave the convention because of the work of the Strasbourg court. Then he said, because some people were laughing, just let you laugh. You were laughing also when we announced that we will leave the European Union, etc. It seemed that all the politicians were a little bit shocked by this fact. And then come and this issue that I mentioned yesterday, the interim measure regarding the deportation to Rwanda. So you could see on the news, among the leading news, that for my surprise, the UK Supreme Court, to put it this way, gave right to the Strasbourg Court, said that Rwanda is not a secure country and people cannot be deported to Rwanda even by disagreement made by the two governments. So that at least shows that the English high judiciary is at least divided on the issue, even if there are very loud opponents of the court. This was accepted because it was really a huge mess regarding the use of interim measures. Of course, the court has in every January a meeting with the highest courts of the member state countries, and there is a workshop which is called Judicial Dialogue for the dialogue between the court and the national judiciaries. This judicial dialogue is a commonplace, it's used everywhere and very often. Probably very few people remember that this expression was invented by the president of the French Conseil d'État, Bruno Genevois, in 1978, when in a case then declared that regarding the relation of the European Court of Justice of the EU, the Luxembourg Court, and the national judge, there should be no place neither for the government of judges nor for the war of judges, but for dialogue of judges, because then this usual accusation, especially in French, is very strongly rooted since the 20s, that the judges are not adjudicating but making policy, and France is not governed anymore by politicians but by the judiciary. So this government, the judges, then it was taken over almost all governments as a rhetoric tool, and he also said that it cannot be a war between international and national judges, but a dialogue is needed. Of course, it's a very nice idea, and I see very strong arguments that really to come to dialogue and not to enter just in conflicts, because one is that the standards, and just say the human rights standards applicable in general today are multiplied. Not by accident, that's a very often quoted idea, is the multi-level constitutionalism. That now the constitutional rights are protected both at, how to say, local level, in the sense that in the federalist countries like Germany, in some of the lands there is a constitutional court. It's protected on national level by the Federal Constitutional Court. Then it's protected by the Strasbourg Court in regard of the convention rights. It's protected by the Luxembourg Court with respect to the Charter of Fundamental Rights, now part of the EU Treaty, and so on. And this would suggest that the protection of human rights is in a better position than before. Going into details, I have the impression that sometimes this multiplication of the levels of defending the court, defending human rights, complicates the situation. So sometimes it makes it more ineffective, this multiplicity of the levels. But anyway, even if you say that this is a development to be welcomed, we can accept that it's necessary to harmonize somehow the case law of the different courts applying these standards. The second is very close to this, the diversification of the national and European jurisdiction. So therefore it's a continuous exchange with the national, domestic judges and the international judges also important. And also that I experienced, and one of the great advantages I was profiting as working with the Venice Commission of the Council of Europe since 1993, and I was also, how to say, responsible at the Hungarian Constitutional Court for the professional international relations with other courts, and it was for me very interesting to find out that these constitutional courts were working isolated from each other and basically were addressing the same issues, sometimes even at the same time. Like in 1973, not only the Supreme Court addressed the problem of the abortion in the famous Roe versus Wade judgment, but in the same year the German, Italian Constitutional Court also faced the same problems, and therefore the Venice Commission created an interaction between the constitutional courts to share the most important cases with us, and the Venice Commission then prepares a short summary of the most important cases of the different countries, and now this database can be used very fortunate way if someone, a scholar or a court judge, tries to go look around the world. Honestly speaking, I found this more effective than the comparative research made by the court that you were asking about yesterday. So the aim is not, how to say, to live peacefully with each other, because of course there are divergences. National courts or national judges usually are critical with some judgment of the Strasbourg court. Some judges reject even the idea of the international jurisdiction, and but I think that the main argument for this interaction of this different levels of the human rights court is to avoid contradictory case law, because then the multi-level approach makes more harm than the unilateral approach. If there is a contradiction, and then you can say that, okay, that's not interesting because it contradicts to this. That one day they say that, we say this, we change our mind, they change their mind, etc. So it's just a mess. And this, of course, the main problem is that with the unpredictability and the legal uncertainty for the citizens, for the courts, etc. Of course, each court cannot avoid to deliver contradictory judgments, and at certain point, when, for example, the Strasbourg courts times ago, well, not judge, delivered 3 judgments on the same day. So then I set a minimal standard for the court, at least not to deliver on the same day contradictory judgments, because otherwise time difference it cannot be avoided. So this is a continuous fight with ourselves, with the courts, nevertheless. But I think that this also, this, how to say, this cooperation also a little bit institutionalized with these superior court networks, which now now embraces huge majority of the Supreme courts and constitutional courts of the continent, and this is a functional relation. The questionnaires are sent to this court to answer regarding the national law. There is a updating on the novelties that the courts work every year for the representatives of these courts or the members of this superior court network, and there is also a continuous interaction with the other regional courts of the world, namely the African Court of Human and People's Rights, and with the Inter-American Court of Human Rights. So now among the three courts there is a permanent forum of international dialogue. Of course, I have to say that they are very different. They have very different powers and practices, especially the Inter-American Court is. I would say that it is that kind of activism what the Inter-American Court exercises, in the sense not dealing with individual cases, but with reports on certain issues that would be unacceptable for the member states of the Council of Europe. And finally, of course, there is a delicate relation between the Luxembourg and the Strasbourg court, which changes as everything historically. This would be the most important at international level, and for me is a delicate and controversial level because of the developing human rights adjudication of the Luxembourg court, then the pending problem of the accession of the European Union to the conventions. These are two, especially this accession to the convention. I was very much surprised that this became part of the Lisbon Treaty, and also in the one-way additional protocols of to the convention. And already in 2013, a draft accession agreement was prepared, which the Luxembourg court stopped the procedure, saying that at the moment the European Union cannot access the European Convention. Of course, I understand that if the EU only states can access the Convention, that would mean the European Union is a state. But I think it is so strange in the system, and this year, against the things were speeding up. In March, there was a meeting of this negotiation group. It's called the 46+1, 46 being the members of the Council of Europe, +1 being the EU. But I don't know. I asked responsible in the Hungarian government what is his task now with this 46+1 agreement. So my task is create as much trouble as possible, and so I'm saying that the devotion of the governments is not clearly in favor of accession. I remember years ago I was a member of a panel that was giving opinion of the candidates for the Luxembourg court, and also at that time, that was under presidency of Cyprus, the EU. They speeded up the procedure, and we had to already elaborate on how the one single judge from the, at that time, 28 or 27 countries will be selected. This will create a huge problem. As my experience was with my nomination to this 7 members panel, Poland was furious. Why not a Polish, and why does a small Hungarian, why a small country like Hungary is represented in this panel as the only one of the, not only of the former socialists, but of the last 15 member states who joined the European Union. And when I had to resign after 6 years from this panel because I became ambassador, and then immediately and automatically a Polish professor, former constitutional judge, replaced me. So I wonder how this one single person will be selected, and then the procedure stopped. But this will, in my view, create a lot of problems, especially because the court is against this provision that is part of the treaty, willing-nilling. And now they are elaborating a new opinion. I don't know the result. That I see is very clear that their huge activism in human rights field has to prove that the Luxembourg court protects human rights at a higher level than the Strasbourg court does. So it makes no sense to join the convention and be represented at the Strasbourg court. This also created conflicts. Don't speak too much of it. And now especially I see that the leaders of my court are very favorable with the Luxembourg court, and especially as always try to avoid conflict or open discussion. But for example, let me quote against the Hungarian case. This was on migration. So migration is a very difficult problem, not only generally in European politics, but also for our court, because migration originally was, how to say, then people left the Soviet bloc and were asking for refugees, or anyways, in Western countries, in Western airports, and so on. And the court was very open to this one and defending the rights of the refugees or migrants, and so on. And then this was continued under the first huge migration, mass migration in 2015, and the following in the following years, and the court opened even more for the protection of these groups, stating them as vulnerable groups, especially even within these groups having even more vulnerable, like the women, the children, traveling alone, but generally it's quite a presumption that all refugees have post-traumatic problems and so on. And this became so largely opened that it created a lot of discussion and criticism, as I mentioned yesterday, not for example, from the government who are in principle very severe and strict on migration, but countries, Sweden, Denmark, especially the issue was on the agenda of the Danish presidency to make it clear that the Strasbourg court is not an appeal court in migration issues, because really those countries who really accept a lot of refugees but reject a part of them, then this part goes to the Strasbourg court, and the court declares violation. So these countries, especially who are really adopting refugees, were very critical with the court. And then in a Hungarian case, it was new in the sense that it was not a transit zone in airports or in special refugee camps, but on the border of the country, the Serbia and Hungary, and whether this transit zone is where the asylum seekers had to wait until their request was adjudicated by the administration and by a court, is detention or not. The original chamber position was that it's a detention because the circumstances are very similar to that. And then the Grand Chamber, to quite a huge majority, an overwhelming majority, decided that although there is a violation of the rights of the asylum seekers because of the circumstances that are similar to a prison, but it's not a detention because they can leave at whatever time back to Serbia, so they are not kept there by force. They also have the physical possibility to leave. 3 weeks later, the Luxembourg court declared in other Hungarian cases, but on the same issue, that the detention in the transit zone, those in the transit zone are in detention. The Advocate General his opinion was even harsher. He was clearly criticizing the Strasbourg judgment. Then at the level of the final judgment, they became more diplomatic, so they are not criticizing the Strasbourg judgment, just basically overruling it. Not overruling because we are not under their jurisdiction, but nevertheless, I mean, taking the opposite position that the Strasbourg court took a few weeks ago. If this is dialogue and not conflict, then we went to dialogue with them to Luxembourg, as the usual meeting every year. I was asked not to intervene on this subject, and then someone else tried to ask some questions in a, so to say, a diplomatic way, but let's check the time because. Well, yes. So I don't enter into this issue because we are probably know well the Bosphorus judgment, the Matthews judgment, and how the courts try to live together. I go to the instead of conclusion. Instead of conclusion, I want just to quote one long sentence from the preamble of the European Convention on Human Rights, because I think that all these problems I wanted to show as problems that require continuous attention between in this delicate relation between the international and national level, different on authorities, courts, etc. I think, and I'm, of course, I mentioned I basically was dealing with human rights since, at least since the mid 80s, even before, and then, of course, from an idealistic view of the classical Western approach to liberal democracy through the concrete, practical successes of building up a country after 40 years of lacking democracy, contributing to this a certain extent, also to see the problem from an international court now, also a little bit being interfered with the diplomacy, how it works and so on. Of course, that the original enthusiasm became a much more, how to say, differentiated. I had disappointments. I'm having disappointment. I saw life is much more complex than reading the books of John Locke, etc. So it's nevertheless, my personal conviction faith in the necessity of protecting human rights and linked together with democracy and not against democracy is remained my personal faith and conviction. And of course, this preambles and declarations are always very nice sentences, sometimes not followed by their practical issues. But I have to say that that this one of these paragraphs of the preamble to the Convention for the Protection of Human Rights and Fundamental Freedoms can also be picked as a conclusion of these 3 lectures that says, reaffirming their profound belief in those fundamental freedoms which are the foundation of justice and peace in the world and are best maintained on the one hand by an effective political democracy and on the other by a common understanding and observance of the human rights upon which they depend. I just reread this preamble yesterday, so that was not the source of inspiration for these lectures, but now I saw that this is somehow summing up everything that I wanted to address. I would just especially underline these 2 words, the justice and peace. I think that's really what we have to keep in mind. And also, of course, the common understanding, so that addresses the problem of universality and relativity or peculiarity of human rights, the common understanding and observance. So these elements, the justice, peace, common understanding, I think that if I want to, how to say, to send a message to you, this would be my message based on almost 40 years of personal experience. So with that, I thank you for your patience and for your very disciplined following of my sometimes persuasive, sometimes confused ideas. And now we still have some time for questions.
Thank you. My question is about a very much discussed theme here in Europe in this period, and I will understand if you cannot answer me. The Italian-Albanian migration deal is the topic of question. And is the European Court of Human Rights currently following the immigration deal in this period? And will the Strasbourg Court take position or judge this deal in the future? Thank
you. By accident, I just mentioned a few minutes ago our migration jurisprudence, which is now, for the moment, not developing really, because since the problem is that we have this, how to say, very permissive and very protective for the migrants kind of jurisprudence, which could be changed at the Grand Chamber level, because there was all these judgments against Italy. The Calafia judgment is really a scandal for the Italian government. And when I arrived to the Strasbourg Court, and the president was that time Guido Raimondi, Italian, asked me that what did the President of the Republic, Mattarella, told me when I was at a farewell visit about this judgment. And I told him that he said nothing about it. He just resigned. He was invited to Strasbourg, and he didn't go to Strasbourg even since then. And but there are no cases go since this Hungarian one, this Ilyas and Ahmed the Grand Chamber didn't deal. Then there was the Spanish case, but the Spanish case was different because there the migrants entered into into Spain by force, and not just for asking for asylum. And we have a lot of cases, for example, in respect of Hungary, especially the expulsion of illegal migrants. This is now dealt with a special committee, which just deals with, so I'm not even member in this, not as a Hungarian rapporteur dealing with these cases. But this goes automatically, it's always violation, because that was the standard set up by the Grand Chamber previously, and until the Grand Chamber does not change this practice, we deal with this quite large number of cases almost as an automatism. Of course, I'm not familiar with just hearing the television with this agreement. Of course, this could come to the court only when somebody concretely applies to the court stating the violation of the rights. I have to say personally that for me, when I arrived to Italy in 2015, and I became acquainted with the migration situation in Italy, I was really shocked. But that was before that the migration wave arrived to Hungary, a few months before. And then I realized that from Gorizia to Palermo, the camps were full, from the Lago di Como to otherwise, we ambassadors also try to visit. I was several times in Sicily. I met at that time mayor of Lampedusa and this doctor who signed the hundreds of death documents. So I was very much promoting the issue that not to leave alone Italy with the migration problem, but then came the Balkanic migration, and again the issue was, I was there when the first allocation of migrants took place, and half of the migrants who were sent to Estonia they escaped from the airport and so on. So it's no, I now see that as the court does not want to change probably. So anyway, for a human rights court, I mean, this would be to step back from a certain standards. So now we just deal under the present jurisprudence with the cases as routine cases. I don't expect in the near future. That's also it's a politician. So I mean, that we leave, I think, to the French Parliament, to the Italian government to make these deals until somebody with a clear application does not arrive to the court.
Thank you.
So my question is on the margin of appreciation. This might actually come off as more of a reflection because you touched upon many points today. But I believe the margin of appreciation is a wonderful tool that shouldn't be taken for granted. However, isn't there the risk of it going too far, of countries using their culture and their tradition as a sort of excuse in order to justify some serious violations of the convention? And my inspiration for this question came partly from the 1995 Otto Preminger Institute versus Austria case, where the Austrian authorities banned a movie that trivialized Christianity in order to defend the Christian sentiment of that region. And this was a clear violation of Article 10 of the European Convention of Human Rights. But the Strasbourg court determined that there was no violation through the use of the margin of appreciation, whereas when a similar situation arose in Rome, the court decided not to ban the movie. So my question is, do you think this could potentially go too far with countries relying on this to escape perhaps an uncomfortable international legal situation? And in an ideal situation without critics about this topic, what could be an ideal, a possible solution to this problem?
Yeah, of course, I had also personal criticism against the margin of appreciation. I also quoted some other criticism, and I can add just to that I also meant that regarding the religious questions, religious etc., the court is criticized from outside by being, to say, a little bit double-faced, distinguishing between the Christian symbols and let's say the Muslim symbols and so on. But I could add something that I didn't not said so far, that yes, the danger is there to introduce, if it's necessary, new elements from the tradition of the country, and for this I could say yes, for the time being a unique judgment, a Latvian case, the Savickas against Latvia, the recent judgment of the Grand Chamber, which was dealing with the issue of the, not that I mentioned before, the former employees of the KGB, but here was the distinction between Latvian citizens and Russians in the territory, because there were different pensions settled for Latvians and for Russians who during the Soviet Union moved to Latvia. And here is an issue that I have not addressed, the problem of the identity, in the sense that in the EU treaty there is a reference to the national identity, and so therefore with regard to the European Union and also to the jurisprudence of the Luxembourg Court, the national identity is discussed very much. Then it became a, how to say, is a trendy topic, the constitutional identity. I wrote once a foreword to a book on the constitutional identity, and I tell that it's okay that we discuss the issue of constitutional identity, but I wouldn't subscribe for that practice when constitutional identity is used to avoid the observance of basic rules of rule of law, saying that this is our constitutional identity, and this unfortunately occurs more and more. In the practice of the Strasbourg Court, as the Convention does not speak of identity, especially not of national identity and the protection of them, etc., the identity, constitutional identity was not raised until this judgment, that surprised a lot of people, including me. Of course, yes, the Strasbourg Court took over the argumentation of the Constitutional Court of Latvia that was relying very much, as a lot of other East European constitutional courts recently, on constitutional identity. But here, basically, then the constitutional identity was formulated as the historical tradition of the country and the continuity of the state identity. So I mean that giving less pension to a Russian in Latvia to a Latvian that is connected to the continuity of the Latvian state. And here, and it's also surprising because a few years before, the court already delivered a judgment on a similar issue and then found violation because of the discrimination of these pensions, but didn't use this argument. I'm how to say, just use this example that referring to the historical traditions, special circumstances, etc. The court is very innovative and can find out things like that. So you are right, the danger is there. So therefore, basically, my answer was that we have to systematically deal with this criticism regarding, for example, the use of similar tools because of the unpredictability of sometimes of the use of margin of appreciation. I think that could be the only to address this issue, not just on the level of individual judgments, but somehow, let's see, at a conference organized by the court or by dealing with it, which I know recently. So since my interventions, since my intervention like in 2008, that was the last time that the court was dealing with this problem.
Hi, thank you so much for these 3 lectures, very interesting. In light of what we said during these days, do you think that the European Court of Human Rights is acquiring features that resembles the one of national constitutional courts, and why? Thanks.
What does with the constitutional court?
Do you think that the European Court of Human Rights is acquiring features that resembles the one of national constitutional courts, and if so,
sorry,
why?
Okay. Yes, yes.
Thanks.
Yes, that's an ongoing discussion recently on the possible role of the Strasbourg Court as a European constitutional court. And this was raised also by some judges of the court, among others, very, even already before, so I mean, even in the beginning, that there is a need for a European human rights constitutional court. But recently, for example, my former colleague from Portugal, Paulo Pinto Albuquerque, who was very strongly arguing in favor of transferring this court into a European constitutional court. I was against this idea, so I was raising counter-arguments, but after another few years, I have to admit that although I do not consider the Strasbourg Court as a constitutional court, do not consider the convention as a constitution for Europe, but I have to admit that he was right in the sense that the court is more and more addressing systemic problems, because before we always said that at least until 2000 or so, the court was very expressed strict on the issue that is dealing with individual violations, and only with that case by case, and not with the general issues. But since the introduction of pilot judgment, systemic problems within the country's legal system, asking for legislative measures by the state to restore the situation, and so on. So this, I have to admit, that factually these showed to a constitutional review role, when not an individual violation is adjudicated on a very concrete basis, but where basically an almost abstract review, of course linked to a concrete case, is made. That's, for example, when we have the pilot judgment on where the government responses by legislation, then we pick one application from the, let's say, 5,000 applications on the same issue that we think that it's maybe the better understandable than the others, And then we say that, for example, the application is inadmissible because there is an effective remedy for the compensation of those whose rights were violated, of all the 5,000 applicants from the prison, etc. This is very close of not only of the role of a constitutional court in concrete cases, constitutional complaints, etc., but this is very close to the abstract review of the legislation. So I admit I didn't change my mind. Do not consider the court as a constitutional court. I'm not in favor to develop in that direction, but these facts that I have mentioned clearly show, and I have to accept it, that the court plays the role of a constitutional court in these cases.
My question is about your perception of how the Hungarian government is acting institutionally in the fight against illegal immigration, and how do you assess the Hungarian government's action in this matter, considering certain sanctions imposed by the European Union on Hungary in this field? I don't know if you can answer to my question, considering your occupation.
Yeah, yeah.
But
no, there's my continuous problems that we very strictly monitor, that not to make any, not to say anything. I'm not saying that not to make political declarations, not to say anything that can be interpreted by the government that I am biased against the government, which basically several times put me in an impossible situation because of certain issues. I cannot, it makes no sense to speak of the subject at all if I cannot speak clearly, and then especially when there might be an access for the court because they are following our statements, or they translate, I think, their articles, etc. No, what I can say, but I would also say that what basically was all the issue of the first question, that we have a jurisprudence on the migration issues, and a very clear jurisprudence on the Hungarian government's respond to the migration wave. Yes, I cannot say more on that we have this jurisprudence, and until that we consider all kind of expulsions, even if they were entering the country illegally. If they would enter it violently or aggressively, then the Spanish case would apply. That it's no violation in that sense. But as these groups who are the applicants in these cases, they enter it illegally, but not using any force against the border guards or policemen, and they are found, don't know, sleeping in the forest, and then they are escorted out of the country back to Serbia, and this is considered by our consequent case law the violation of the convention. Even if I say I am now rarely rapporteur, or not even member of the committee that decides on these cases. I decide when some new elements are for example, when one of these migrants died because of the police atrocities. They were swimming in the river, and the policemen were throwing them some stones, and the dogs were chasing them in the water, so one of them died there, etc. So that's what I can say at this moment.
It's me. I want to say thank you, because I'm glad to be here. You had a life full of experience, rich of experience. I have two questions. First of all, I'm here as an immigrant, illegal immigrant. I enter Italy, illegal immigrant. And since I arrived till today, I saw and I see the things is getting worse in Italy year after year, and the government hands are tied. To be specific, because of Dublin agreement, will we see update about this agreement or any change soon? Second question, you make refer that you study Machiavelli in the time. And yesterday also you made the refer in Machiavelli. Machiavelli in his book, The Prince, he mentioned that there is no morality in politics. And also the teachers here, they always repeat to us, you need to detach your feeling from politics. I have a question from a person who reached this point because of his emotions, his morality. I want to change something in life, but I have morality and I have emotion also. It reached me to this point. I need to change because there is no politician, no emotion in politician, or no morality, or what? I need something from you. I need a comment from you. Thank you.
So we were asking whether there will be a change in the court's jurisprudence regarding this. I couldn't.
I'm asking from your point of view, from your experience, because you had your background and the life you lived till now. I need experience from your point of view. And the first question about from jurisprudence experience.
Regarding migration.
The second question regarding your experience. It's a personal question.
But on what? What topic?
That we have to change, that we need to change. There is no morality in politics. There is no emotion in politics. We need to detach our emotion from politics regarding everything is going around the world right now. Because to me it's impossible to close our eyes and everything is going around in the world right now.
You know, I cannot speculate or speak on behalf of politicians. So what the politics, how will be changed? We just can influence politics by our judgments, and in this sense, as I was already mentioned before, for the moment I don't see change in the jurisprudence of the court. I don't see change in the jurisprudence of the court. I don't know. There are small changes. Comes to my mind that, for example, this I see that the just satisfaction, which is assigned automatically to the asylum seekers, is lower. Recently, is lowering. So the essence of the judgment is the same, but the just satisfaction given to the applicant is sometimes lowered quite much, like from 10,000 to 1,000 or 2,000. But in the serious violations, it remains still. I'm just seen maybe still coming up Hungarian cases where 17,000 is the just satisfaction for those who were expulsed. I mean. Sent out of escorted out of the country without having any violation. Then they come. There was also violation. Then there's another just satisfaction. But I'm afraid, well, in this sense, I couldn't really exactly understand your question. So maybe I was not answering for that.
Thank you.
Is this lady here? Then?
Somebody here?
Firstly, I wanted to thank you for your presence here. For us, it's a really great honor. I wanted to ask a question about a specific country. Some of us had a previous seminar with a Turkish teacher about democracy in Turkey, and he told us that the Court of Strasbourg never sanctioned the various and continuous violations of human rights that Turkey made. So my question was, why there was never a sanction for Turkey? Nowadays, Turkey is even the biggest country, is the country with the biggest number of journalists imprisoned. So I really wanted to ask why the court never really reacted to that.
But, in my views, Turkey is really in the focus of the attention of the court. So I'm not in the section where the Turkish cases are dealt with, the section 2, I'm section 1. But I have a good relation with both with the previous Turkish member of the court and the present one, both professors of law, and then I'm somehow I'm updated on this flood of Turkish cases regarding violations. I was member of the composition of several Turkish Grand Chamber cases, and I was in the Beşiktaş case. I was dissenting from the majority, together with the national judge, the Professor Saadet, and with the Georgian judge, because concretely with understanding the violations that were committed against him, so I could not abstract myself of his very clear political background, and then there were a lot of cases also before the. Now I was just a substitute member, so I was following the deliberations and also the hearing, but my name is not on the judgment, of course, because I was just substitute. Regarding the Yeltsinskaya case, regarding this the revolt, what was considered was a revolt as such. So I think that now Turkey, after the Russia left, and then Ukraine is somehow dealt with a special way. So a little bit the Ukrainian cases are a bit set aside, not to. So we are not elaborating on the Ukrainian cases with that speed as before, because we saw that the war would be over, and so on, etc. So now basically I think that Turkey is the country from where almost the highest number of applications pending before the court, and also Grand Chamber cases, almost 2 times a year, and so I think it's a how to say, and I know from the national judge the problem that I referred to yesterday, that she cannot deal with all these cases, but she has to have an opinion as national judge on all these cases. So she's working several times more than some of the other judges. I have to say, even me with the 600 applications, I am quite uncomfortable. We are not in the top 10 anymore, Hungary, so it's
Hello, I'm here.
Ah, sorry.
Hi, sir. I have a question. When you come up with judgment and opinion, I want to assume that you don't do it in a vacuum and there is no external influence by some actors like NGOs, businesses, or other external, again, actors that want to influence your opinion and into a particular way. And my question is, what are the actors, if my assumption is true, and who exert the most influence, maybe it's even members of the public or your relatives or media. And is it the same composition and their power as it case for Hungary and Strasbourg, your current occupation?
Yes, it's an important question. I have not addressed this. The influence is to a certain extent regulated by the court. So third parties can enter any procedure, and they do. And these are mostly NGOs. Nowadays, I have to say, not only NGOs, human rights NGOs from the classic liberal human rights NGOs, but now I see more and more NGOs against abortion, against same-sex marriage, etc., also entering into the field. And the court officially has a close relation with the NGOs. So there is a meeting every year for the government agents who are representing the government, and there is a meeting every year with the NGOs. Actually, we had a few weeks ago. And then they are invited, they are updated, and etc. We have a lunch with them, and can discuss with the, for example, from Hungary, now there was a Hungarian Helsinki committee represented, and so on. But this is regulated, and the president of the section or of the court has to give a permission for entering and presenting the opinion of the third parties, as we call them. Then it's another issue, but closely connected to your question, that there are allegations that certain NGOs have an impact on the judges of the court. This is especially developed by another NGO, this Law and Justice Institute or Society, has seated in Strasbourg. They made a study that how many judges of the court were connected in their previous life to NGOs funded by George Soros. And they made a list. Then these judges didn't even deny. So they say that someone who was a human rights activist or a lawyer in human rights cases, sooner or later gets a bit to one of these NGOs that is funded by Soros. They were not excited on the issue. There was also initiative for a kind of referendum on the issue, but that was rejected by the Parliamentary Assembly and so on. As regards any personal, honestly speaking, it's a little bit similar to the issue of the comparative studies. So these are very politely listed. These arguments are taken to consideration. These, some of these interveners can also present their arguments at the hearing publicly, besides the government and the applicant, the parties. But as far as I see, they did not have a very direct influence on the outcome of the judgment. As regards personal, so to say, illegitimate influence, I have not experienced. Even we avoid, at least me, and probably they know that it makes no sense, but I think that in general is that we don't discuss even the cases with each other, so not to have the impression that we are influence the other judge, which I have to say at the Constitutional Court, my experiences were sometimes different. So there were seen presidents who tried to persuade the judges, especially the judge rapporteur on certain issues. But as regards the Hungarian court, where the president has the discretionary power to assign the cases, of course, with the assigning of the case to a certain judge, you already influenced a lot the outcome of the case. Yeah. Okay.
I have a question right here.
Yes.
Hello. First of all, I wanted to thank you for giving us the time of your day. It's honestly an honor. For my question, I am an Iranian woman. I recently came to Italy for education. It is no secret what Iranian people are undergoing by the hands of the Islamic Republic regime in Iran.
Yeah.
Especially from last year, the situation in Iran, the dictatorship, the femicide, the genocide based on religion, belief. There are many articles, all of the articles in the Declaration of Human Rights that are being violated on a daily basis in Iran. As I'm speaking right now, from the beginning of this month, 9 girls have been murdered by their fathers or brothers due to religious reasons. And from the beginning of this month, again, actually this week, 5 people have been sentenced to death for the protests of last year.
Yeah.
What is the obstacle, if there is any obstacle, even like also considering the fact that us Iranians have been asking for sanction enforcements on the Islamic Republic? What is the obstacle that the Court of Human Rights meets that kind of allows them to maybe overlook the situation in Iran? Because, like I said, we have asked for sanctions, but it's completely been overlooked by the United States, and they have released billions of dollars to the Islamic Republic, which they use to commit genocide, not only in Iran, but in multiple countries in the world. So I wanted to ask, what is the obstacle, if there is an obstacle, that the European Court of Human Rights is meeting that doesn't allow them to help us, help me as an Iranian woman, and many other people inside of the country?
Yeah, the problem is the problem of the jurisdiction, because if you are here in Italy and, for example, you are discriminated for whatever reasons and whatever violations you personally suffer, you can go to the European Court of Human Rights because you are on the territory of a member state. But what regards Iran, the jurisdiction is at these UN institutions that I just mentioned, for example, and didn't want to be very tough on the issue that these are not always very effective, this Human Rights Council and so on, because then what the European Court of Human Rights is dealing also with issues committed in other countries, but only when a member state violates the rights. So that was the case in Afghanistan, when British soldiers were committing violent acts against Afghani people. That was in the jurisdiction. If the British army would commit violent acts against these women, but they are the problem is with their own government. So the European Court of Human Rights does not have jurisdiction on for Iranian. No, the United States has nothing to do with it.
Because it's like giving money to terrorist governments, for example. It's opening money to a terrorist government, the Islamic Republic, for example, giving access to billions of dollars, which are used right now in Ukraine to send bombs to Russia and bomb Ukraine. Russia. No, not Russia. I'm saying to sell bombs to Russia to throw into Ukraine, which is also a part of the European Union.
Yeah, but Ukraine is part of the Council of Europe, Iran not. So it's, this court does not have jurisdiction outside the territories or outside or for crimes committed, violations committed by governments that are not members of the Council of Europe. So it's, that's the obstacle to deal with these cases. All the left is, how to say, international politics, so how the governments behave and handle this issue. That's not the court's role. Okay, I think that we exhausted ourselves and the subject.
Yeah, yeah. Maybe it's the final.
Yeah, countdown.
My question is regarding lobbying. How do you discover nature of private group that tries to lobby and use their influence to modify or contrast the human rights court? Are there active lobbies or factions inside the European Union that have fought to modify the work of the Human Rights Court to further their interest? And how does the court fight their influence and defend itself from their action?
That's a lobbying activity in the sense, besides that what I mentioned, the former questions, intervention into the cases as well and so on, is that of course outside the concrete cases, these NGOs and other organizations, and and speak of NGOs, I speak both NGOs linked to the liberal tradition, also this NGO who is inquiring on so-called Soros agents and so on. They even not intervening in concrete case, of course, they make studies, they publish articles, books, which they clearly decided also to influence the court in the sense that take into consideration that there are these views, they are criticizing the court, they are also lobbying for in goodwill or in bad faith to amend the convention, to, for example, let me mention right to healthy environment. There's nothing said in the convention, nevertheless we have quite a vast jurisprudence on it, and then there is a lobbying activity which is addressed not that much to the court but to the states, to the governments, to adopt another additional protocol that would introduce the right to healthy environment, etc., to the convention. Their conferences are organized for that, and that was a big disappointment for these groups, also to lawyers who sympathize with them at the court and so on, that there was a conference, and the former president of the court was invited to open the conference, and everybody expected that he will lobby in favor of adding the right to environment into the, and he actually was arguing in favor of the contrary and so on. So that's of course that there is a, but this I consider until it's within the boundaries a legitimate thing to, especially in an organization with 46 countries, to raise ideas, to be critical with certain developments, or to lobby for changes. Yes, and that's ongoing. As I say that all these jurisdictions are functioning on the borders of politics and law, so I think it would be too naive to say that there are no lobbying, there are no how to say attempts to influence the court. So it would be a naive position. That's as I experienced in the case of constitutional courts, also at the international courts. There is this kind of activity, so we have to be aware of that and then keep somehow to distance with this. That's one of the reasons that we cannot express ourselves even on very important and actual issues that would be kind of political statement on our side.
Alessandra, do you mind?
Last question, I think. You said in this lecture that in the 90s, at international level, there was the Commission for Human Rights of the United States. And what do you think about the recent disappearing of the role of the United Nations, also referring to the question of the girl next to me?
I'm start to be, how to say, reserved on this issue, but all in all, I consider the UN human rights mechanism not really effective. The problem is that even in the composition of these councils, committees, etc., I mean, rotating base, countries are represented, which cannot be called democracies at all as well. So I mean, and then if you look at these genocides and all these wars going on, for example, in the African continent, it seems that not only that these councils are not effective, the problem is that the international community as such is not effective. Then if they interfere to protect the human rights of a certain part of the population, that they are accused that they are intervening, not because to protect, but just to intervene. And also one other that I mentioned, the accusations is that they have double standards, so they interfere into the internal politics of countries under the slogan of protecting human rights, and in the meantime they ignore human rights violations in their own countries. So therefore, with all these problems that I've raised, for example with the European Court of Human Rights, I saw that this is a much more effective mechanism, even if it's not, it cannot solve by far all the problems, but at least it works more effectively.
Thank you very much.
You. Okay.
I think we're done. Okay. Well, thank you very much, everybody, for being here, for your participation. But I would like to ask you to join me in a round of applause to thank, the Honorable Judge Péter Paczolay.
Okay.
Thank you very much. Enjoy the rest of the day.
Thank you. Thank you for your attention.